All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of evictions and knowing your rights. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. But also included, we have the City of Houston's Department of Neighborhoods, and joining us today, we have Ms. Cecile Carlson. Also, on behalf of our presenting partner with Lone Star Legal Aid, we have Mr. Benjamin Daly, who's going to be providing the information for you today about evictions and your rights as tenants. But also included in our partnership, we have the Earl Carl Institute, Texas Legal Services Center, the Harris County Attorney's Office, Houston Volunteer Lawyers, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up a month of service. And basically, a month of service is the collaboration of all of our organizations coming together on a monthly basis and offering a variety of different workshops, resources, and information to the community relative to community empowerment, um, uh, uh, maintaining generational wealth, asset building, and asset protection. We try to get together and provide as many resources and information, especially a lot of those related to laws and your rights in the state of Texas as we possibly can to the community. That we know that there's a lot of underserved communities that are out there that don't have access to a lot of information, don't know where to go for available resources, and evictions, unfortunately, is one of those things that are plaguing a lot of communities that are out there that don't know the basic rights as it relates to eviction. So we decided to collaborate several years ago and pool a lot of our efforts and a lot of our initiatives so that we can try to create a larger impact and try to disseminate as much information out to the community as we possibly can, most accurate and up-to-date information as we possibly can that relates to our communities and the state of Texas. So know that regardless of where you are joining us from today, that the information that does get presented here today is relative to the laws, the eviction laws to the entire state of Texas. So it's not just for City of Houston or for Harris County, but it's also surrounding counties and across the state as well, as I mentioned. This is your opportunity to ask questions, to get as informed as you need to be as it relate to landlord tenant laws and your and eviction proceedings and what your rights are as a tenant. So we do hope that the information that you intended to receive today is the information that you do receive. Again, this is your opportunity to ask questions of a legal professional in the area of the evictions. Feel free to type your question into the chat or unmute yourself and wait until the end of the presentation and you can ask your questions directly. We do broadcast on our social media platform live on YouTube and share across our other social media platforms. So we do want to try to protect your privacy as best as we possibly can. So we ask that you just try to keep your questions to be general and not to divulge any personal detail information. However, if you do find yourself in need of any civil legal assistance or any personal or one-on-one, we do ask that you reach out to Lone Star Legal Aid or our other legal service uh, partners for more detailed and more specific as it relates to your particular situation. If you are joining us on our social media platforms, please feel free to type your question into the comment section, and I'll make sure that your question gets addressed aloud, get addressed at the end of the presentation as well. So you do have that opportunity to engage. So without further ado, I think we're going to go ahead and get started. There has been some changes that Mr. Daly is going to go over as new laws or new processes that have changed as it relates to evictions, so that you guys again can get the most up to date and most accurate information. So we're going to go ahead and get started with our present our introductions and move on into our presentation. So we're going to start with Ms. Cecile, and then we'll have Benjamin introduce himself, and we'll move right along. So Cecile.
Hi, thank you, Nia. Good afternoon, everybody. Welcome to another AMOS, a month of service workshop. Just want to welcome everybody and thank you guys for being here. And thank you as well to Lone Star Legal Aid and to Mr. Daly for being here today, presenting, like Nia said, the most up-to-date information from the professionals And remember that we have our workshops online, pre-recorded if you guys want to go back to some of the other workshops that we've had. And then make sure that you let people around you know that we're here offering information for the community to empower everybody to make the right choices for themselves. So thank you so much. And I'll go ahead and pass it on to Mr. Daly.
All right, Benjamin.
Okay. Well, thank you. My name is Benjamin Daly. I'm an attorney with Lone Star Legal Aid. And assuming everyone can see this, this is Eviction Know Your New Rights.
Ah,
As
yep,
many of
got
you
it.
know, that eviction laws changed. Some places rise significantly at the beginning of the year. And so this is the most up-to-date information that we have on that for you. Before we get started, special acknowledgement to my colleague, Kim DK, who is responsible for much of this presentation. Lone Star Legal Aid is a nonprofit law firm. We represent low-income individuals in a variety of civil legal matters. We have a variety of units. Some are specialized, like mine, to handle one specific area of the law. Others are more general, but they gear their practice towards helping specific members of groups, such as our Veterans Unit or our Crime Victims Unit. We can offer everything from simple advice to full representation. And if you're eligible for our services, they're free. So we'll go over how to apply at the end of the presentation. Some things to go over today. We're going to provide some general information on what to expect in an eviction lawsuit, as well as some other issues you might come about as part of a landlord-tenant relationship. We'll be providing general information, but be aware cases often turn on specific facts. If you want questions answered about a specific set of facts, you may want to apply for our services. As always, when you're confused about your case, it's always a good idea to ask a legal professional for help. And generally, if you are looking to file a lawsuit, we highly recommend that you speak to a lawyer before doing so. Brief note on sort of the currentness of this presentation. So last session, the Texas legislature passed SB 38, which was an overhaul of the Texas property code related to eviction proceedings. A lot of these changes are kind of unsettled because we don't know how specific courts are going to interpret the law and apply the code. Other areas may be subject to constitutional challenges, and even something simple as the rules of civil procedure may be subject to change. So we're giving you the most up-to-date information that we have. Be aware, though, some of these things may be subject to change as time goes on, as the courts look at these laws further. So just be aware. If you still have questions at the end of this, or if you have problems in the future, it may make sense to come back and see us and hear sort of what those changes might be. So to dive into it, the most important document in any landlord-tenant relationship is going to be a lease. The lease is the basic agreement between the landlord and the tenant. It'll establish the rules regarding the use and occupancy of the dwelling. That's a fancy way of saying that your lease is an enforceable contract. Texas allows for both verbal and oral leases. We highly recommend if you have an oral lease, you take steps to document the terms of the lease. Keep in mind that if the lease term is for longer than a year, the statute does require that the agreement be in writing. Leases are going to control in most disputes, and leases under Texas law have a lot of power, including the right to change certain timelines and waive certain rights. Under the property code, you have the right to a copy of your lease within 3 days of being signed by all parties. If you don't receive a copy of the complete lease, you want to ask your landlord for it in writing and document that you've made that request. Some important things to note about what's in a lease. A lease should contain information about the monthly rent. It's going to tell you where and when to make payments. It's going to provide information about late fees or other types of fees. It'll also usually contain language stating how the payment is to be applied. The current standard TA lease includes language that basically says that your landlord can take rent payments and apply them to any outstanding sums. And that could be significant if it comes to an eviction, as far as whether or not they can bring a suit for non-payment of rent. The lease agreement should define what the initial lease term is. Most leases that are in writing are going to be for a term of a year. We do, however, see month-to-month leases on occasion, especially when you're dealing with sort of short-term rentals. It may also contain language that states that the end of a lease term, if a new lease is not signed, that the lease would convert on the same terms into a month-to-month tenancy. And some leases also provide for an additional fee should that occur. It'll provide information about community rules and policies. Many leases have language that specifically incorporates the community rules, which would be a separate document, into the terms of the lease. So even though they're technically two separate documents, because it's incorporation, the rules, the community rules, become actual part of the legal lease. A lease will include signed addendums. If you're in subsidized housing, it may contain a HUD or HAP agreement that could modify the original lease. The addendums could include concessions. So if you move in with some sort of special, the addendum may contain information about sort of what's being conceded there. It'll define what acts of default are. So it'll talk about failure to pay rent. It may define what a material breach of the lease is. It may define when early termination is allowed, or if early termination isn't allowed, what sort of penalties there might be. It'll define what timelines are in some cases. So like I said, there are some leases that are allowed to alter certain timelines that would otherwise be provided for under the property code. So for instance, changing the deadline for a notice to vacate from 72 hours to 24 hours. Finally, it'll contain an authorization for electric communications. Electronic notices aren't new, but in the past, something like notice to vacate could not be sent via email. The new law changes that. And so you want to review your lease and make sure that there is or is not authorization for electronic communications, because that could affect whether or not they're able to actually send you a notice properly. Let's talk briefly about termination. So before any sort of eviction is filed, the landlord is required to terminate the lease. Likewise, a tenant can also, in certain instances, terminate the lease to avoid certain penalties or basically just to end the relationship. Most leases, however, are terminated at the end of the lease term. Before the lease is terminated, there has to be some form of written notice, and notice does need to be in writing the lease is being terminated. If the landlord is terminating the lease at the end of the lease term, it should contain language about when the term comes to an end and when they're asking possession to be returned. If the landlord provides that information and the tenant stays after the date, they become what we call a holdover tenant, and they become vulnerable to eviction at that time. It's an important note because we sometimes get these questions about whether a landlord can terminate a lease at will at the end of the lease term. Except in very special circumstances, your landlord cannot make you renew your lease. Sorry, you cannot make your landlord renew the lease. Likewise, the landlord can't make you renew the lease as well. We talk about termination during the initial term. That is, while there's still an agreement with a deadline in the future, we call that an early termination. And that's going to be our subject next. Before we get to the eviction side of this proper, it's important to note that the tenant has, under the code, specific rights to terminate a lease early without penalty. These sections are in the property code. I won't spend a whole lot of time on them. But if you're a victim of family violence, you can request early termination. If the tenant dies during the lease term, the estate can terminate to avoid future liability. And then It also provides that in cases where someone is going to be deployed, the service member can also exercise the right to early termination. Now, as you can see, some of these provisions cannot be waived by the tenant. Some of them can, and some of them require special notice. If you think that you want to terminate your lease and you fall into any of these categories, our recommendation is to review the code prior to terminating and make sure that you're complying with the terms of the statute. The codes can spell out in detail who's covered and what sort of notice is required. Keep in mind too, some of these statutes provide cause of action against the landlord, which means if the landlord violates them, then you may have the right to sue them. We recommend speaking to a lawyer before attempting to sue the landlord, though, so be aware of that. The final type of early termination I want to spend some time on before we get to the eviction is what we call casualty loss termination. Those are cases where the property is damaged due to a disaster. So if your house is flooded, if the wind knocks in the walls, if there's a fire, the terms of TPC 92.054 are going to control. And the important takeaway here is that either party has the right to terminate the lease if the property is made totally unusable and it's not the result of a tenant's fault or negligence. If for some reason the premise is damaged by casualty loss, but is not made totally unusable, but instead partially unusable, then neither party has the right to terminate early. Now, keep in mind whether the property is totally unusable or partially unusable is going to be a fact question. So we're coming up on hurricane season in the next few months. If, God forbid, something should happen where you're facing a casualty loss question, we recommend talking to a landlord. Sorry, I can't talk today. We recommend talking to a lawyer before taking action against your landlord on this. So now we get to sort of the eviction side of this problem, which is termination of a lease due to a breach. Breach of lease is basically a violation of the lease terms. The lease should define what a breach is. As we mentioned before, that can be something like non-payment of rent. It can also be a violation of the community rules or addendums. So you want to review your lease agreement and you want to review any addendums. The common defaults, like I said, it's failure to pay rent by the date stated in the lease, unauthorized tenants, criminal activity. In some cases, it'll specify that holding over is a violation of the lease, although by that point, they should also be vulnerable as a holdover tenant. If the breach of lease occurs, the landlord is required to provide a notice to vacate prior to taking action on this. Before we get to that, though, brief note, because we do sometimes see cases in which a tenant might withhold rent, usually in relation to some breach of lease by the landlord. Specifically, we see a lot of tenants who ask for repairs. Repairs aren't made, and so they withhold the rent. That is a very bad idea. It's safe to assume that withholding rent is a breach of the lease, and Texas law requires rent to be paid in full and on time as it comes due. You also have to be current on your rent to maintain your right to repairs. Once you fall behind, the statute is specific that the tenant does not have rights to ask the landlord to fix anything. Repair remedy claims need to be brought separately against the landlord. The first step to basically getting that ball rolling is to send the landlord a written request. We recommend via certified mail because there's a second notice requirement if it's not sent by certified mail. And then you want to reach out to a legal professional to assist you with next steps. So notice to vacate is basically the first document that you're going to receive if you're facing eviction. The landlord is required to give this in all cases before bringing the suit. The code requires a 3-day notice, but as I mentioned before, the lease does allow the landlord to change that timeline. And there are some federal statutes that may also change that timeline. So be aware the 3-day notice is, at least in theory, standard, but you want to check your lease to make sure it's not allowed for a lesser amount of time. The code defines proper delivery as personal delivery, so hand delivery, mail, so either regular mail, registered mail, or certified mail. It allows for delivery to be done by posting the notice inside. Well, technically, it shouldn't be inside the front door. The current code says that it needs to be inside the unit in a quote unquote conspicuous place. And that means that that becomes a fact question. In the past, it's required that be posted on the inside of the front door. My guess would be that similar posting would certainly be allowed. Posting other places, largely depends on what gets argued in front of the judge and how the judge actually approaches that question. And finally, they can now deliver notices electronically if the parties agree in writing to authorize the delivery. So notice delivery by any of those four methods satisfies the code. But there's now an additional provision which states that even if the landlord fails to deliver the notice properly, that if the tenant actually receives the notice, then the notice itself is valid. So it used to be that a failure to properly deliver a notice to vacate would be ground to dismiss an eviction. That is no longer the case. Now, we do still recommend that people document when and how they receive notices to vacate, especially if the notice was delivered incorrectly, simply because if the tenant actually received the notice on a later date, that potentially could affect whether or not a judge would be willing to grant judgment. But certainly, the scope of defenses under a notice to vacate defense has dramatically narrowed. Another sort of new development is that the property code now contains a very limited right to cure in cases where a tenant is late on rent and has not been late prior. So the specific requirements are that the grounds for the eviction be non-payment of rent, and the tenant has never been late or delinquent under the current lease prior to the current default. Important to note that if there is a new lease agreement, the clock resets. And so that means a couple of scenarios may be covered by this requirement to allow the tenant to cure. The first instance would be a lease extension. And the second instance would be if you're on a month-to-month lease, it may be that every new month constitutes a new lease agreement. Certainly, I expect that this to be fiercely litigated, and so I'm sure we'll have more information for you as time goes on. But that is our current read of this particular section. Now, those to pay rent or vacate must include demand that the tenant either pay the outstanding balance of rent or that they move out by final date. Note that a deadline to pay, becomes sort of a deadline to pay. So if you tender the amount demanded in the notice, the landlord must accept it. Important to note, if the landlord takes any steps which might hinder your ability to make the payment demanded in the notice, you want to document that and provide evidence of that to a judge if it does end up, going before an eviction court. So a specific instance, it's an area we're thinking of, is a lot of landlords have online portals where they want the tenant to pay. And when the tenant is late or doesn't pay, those portals get shut off. If you document that you did not have access to the portal during the period before the deadline, then you may be able to argue that the notice itself was improper or that the landlord, basically shouldn't be able to win a case like that. Again, it's something that we're going to see fiercely litigated, but our position is you want to document if you tried to make payments and haven't been able to because the landlord interfered. And we'll talk a little bit about what that looks like in a couple of slides. Keep in mind too, let's say that you have a landlord and the tenant has been late in the past under the same lease, and they provide a notice to pay or vacate. The terms of notice to pay or vacate, our position would be that those would be enforceable. So even though the code does not provide the tenant a right to cure, a landlord could provide a right to cure by providing a new notice to pay or vacate. So, if pay attention to the actual language in whatever notice you might receive. Also important to note what they can demand under a notice to pay or vacate. The statute specifically makes reference to rent. Rent is going to be defined by the lease, but it's usually the base amount that you would pay to stay. Would not include late fees or utilities in a lot of instances. TA lease also allows for what they call other rent, which would be other fixed reoccurring charges. We've heard a presentation from one of the councils at TA, and their position is that if a tenant receives a notice to pay rent or vacate, and the tenant pays rent, even though there may be other sums owed, the landlord would still be required to accept the payment. However, it's important to note that the failure to pay those fees or utilities may constitute a separate breach of the lease, and the landlord could issue a new notice to vacate, under those breaches in order to try and get an eviction. So just be aware, best practice if you get a notice to cure, it's best practice to pay everything that would be owed and avoid the possibility of a second notice. So I said we would talk a little bit about what happens if a landlord refuses rent. Under Texas law, landlord's not allowed to refuse properly tendered rent pursuant to the lease agreement, or if there is a notice to pay or vacate, they should also not be allowed to refuse amounts tendered under that notice. Now, a landlord does have the right to refuse rent if it's late, if it's a partial payment, if it's offered in a manner inconsistent with the lease, or if the lease has been terminated or an eviction suit has been filed, they can also refuse. So what do you do if rent is refused? The first thing you want to do is review your lease, notices from the landlord and or current ledger. Make sure that the amounts you're offering are in full. So in other words, either they're the right amount that's being demanded under the notice, or this is the right amount that's owed according to the ledger, or if you don't have a ledger, that it covers all the amounts that the lease agreement requires. Make sure that's offered in a manner consistent with the lease of the notice. If the landlord requires in the lease that all payments be made via money order, and you're offering a personal check, they may have a right to refuse because it's a personal check. So, just make sure that the payment's being offered consistent to what's required. You want to document the date and the manner of payment. You want to document correspondence with the landlord about the issue. If you pay rent via portal and you're locked out and you can't tender rent that way, you want to document that the portal's been shut off. You want to keep payment or funds available for future payments, because even though they may be refusing them, you may still need to tender that rent in the future. You should continue to offer rent in full and on time for future months. Tender the rent even if the landlord refused in the past, and even if they state they're going to refuse it. And just make sure that you've documented that you have properly tendered timely. And then finally, this is an instance which we highly recommend contacting an attorney for assistance. Also new under the notice to vacate is that there's a new provision that subjects the notice to vacate to the computation rules that the court uses for other documents. The basic rules are that, the basic rules are that time starts the day after notice is delivered. If the final day ends on a weekend or a federal or state holiday, the deadline is extended to the next business day. Aside from that, all days are counted. If the eviction is filed early, that could be grounds for judgment for the defendant or dismissal. And so just to sort of illustrate what we're talking about, we've got two scenarios here. So let's say that the landlord has a tenant who has not paid rent in February 2026. And they deliver a notice to vacate on Wednesday the 4th. Day one would fall on the 5th, day two would fall on the 6th, and day three would fall on the 7th, which is a Saturday. Because it's a Saturday, the deadline under the new rules would roll over to the Monday. And if the tenant does not vacate by the end of the day that Monday, then the landlord could file the eviction on the 10th, that Tuesday. So that's scenario one. Scenario two, let's say that the notice delivery happens on the 11th. Day one would fall on the Thursday, day two on the Friday, day three on the Saturday. Likewise, it'd roll over to the next business day, but because the 16th is a holiday, President's Day, it would actually roll over to the 17th. That would be the deadline to leave, and then the landlord could file on the Wednesday, the 16th. Sorry, Wednesday, the 18th. I am not sure how that happened. Anyway, that's supposed to say the 18th. Now, note if you are looking at a computation of time defense, there's another area where we recommend getting an attorney. There's another area where we expect there to be some pushback from the landlord bar as to our interpretation. We're confident in it, but it may take a fight to get the judges to recognize it. Let's talk briefly about the CARES Act. As I mentioned, that there was at least one federal law which could change the timelines required by a notice to vacate. CARES Act was COVID era policy. Originally, it created a eviction moratorium for cases where the tenant was on a property that was either covered by VAWA, and VAWA properties include a number of subsidized public housing programs, Section 8 housing vouchers, low-income housing tax credit properties, rapid housing, or if they were on a property that was backed by a federally backed mortgage. So you're talking Freddie Mac, Fannie Mae, Fair Housing Act, or VA. After the expiration of the moratorium, there was a new provision. Well, there's a new requirement that the landlord give a 30-day notice to vacate prior to filing the eviction suit. Up until now, Texas courts have, by and large, recognized that 30-day requirement. The new law tries to change how it operates. So their position under Texas Property Code 24.005C1 is that landlords are not required to wait 30 days before filing an eviction after giving a notice. They can file as soon as the notice required under 24.005 generally, till that deadline expires. It also doesn't allow courts to dismiss or grant judgment to tenants due to lack of a 30-day notice. What it does do is it basically requires the courts to delay a writ of possession from being executed until 30 days after the notice to vacate was delivered. This is an instance in which if you think you're in a CARES Act property, you need to talk to a lawyer. Because there's definitely a clash between the Texas law and the federal law. And this is an area that is going to be fiercely litigated. You need to be aware that justice courts may take different approaches to the CARES Act defenses initially. You need to be prepared to appeal, and we'll talk about how to do that later. And you should keep up with these presentations for updates on what to expect. But our position right now is that CARES Act requirements are still in existence. Keep in mind too, Texas Property Code 24.005C1 does not override a lease in which a 30-day notice is required. I haven't taken a look at the latest HAP contract. If there is a 30-day notice requirement written into that contract, then whether or not Texas law requires the courts to abide by the CARES Act, there's still a contractual right to a 30-day notice. So now we get to evictions and the eviction suit proper. So an eviction is a suit specifically to determine which party has a greater right to possess the property. A landlord seeking to succeed in writ of, I'm sorry, a landlord seeking to win an eviction suit has to show a few things. They have to prove they're the owner. They have to show that there's a breach of a lease or termination at the end of the lease term. They have to show that they provided proper notice under the property code and asked the tenant to vacate, or if the tenant's already received a notice to vacate, whether it's delivered properly or not, the landlord has to show that it was actually received. And then they have to show that the defendant refused to leave the property by the deadline to vacate. You want to pay attention to the date the eviction lawsuit was filed. If the landlord tries to shortchange the tenant on the date and the time, that's ground to get the case dismissed or a judgment for the defendant. In addition to the question of possession, in cases where there's non-payment of rent, the landlord can ask for back rent. We call this an additional suit for rent. Important to note that the landlord can only ask for base rent. They cannot ask for late fees, past due utilities, or other sums, which would normally require a separate lawsuit in small claims court. Important to note, the landlord can also get court costs and attorney's fees if they seek them. But as far as actual damages, it's only back rent. We do sometimes get questions about sort of the nature of these cases. Almost all of these cases are going to be tried in bench trials, which means that the judge will be the final decider of fact and of law. If you want a jury trial, you do have a right to request one, but you have to timely file a request, which would be 3 days prior to trial, and you have to make sure that attorney fee is actually paid. Or if you can't afford to pay the fee, you can submit a fee waiver to see if the court will grant it. If you don't file the jury demand timely, you don't pay the amounts, and the amounts aren't waived, then you do not have a right to a jury trial. I want to spend a little time on sort of the first steps and deliver a citation because there's one change in the law that is potentially insidious, and we want to make sure that you go in to a situation with eyes open for this. In all lawsuits, after the plaintiff files the lawsuit, the defendant has to be served with citation. This is basically a copy of the petition as well as information from the court stating that the suit's been filed and providing additional information on when court dates are going to happen and what sort of filings might be necessary. In an eviction case, trial has to be held between 10 and 21 days of the filing of the suit. The defendant must be served citation at least 4 days before trial. And if the landlord requests citation, but citation isn't delivered within 5 days of suit being filed, the landlord may ask a different law enforcement officer to serve the citation. Why does this matter? Well, there's a distinction between two types of defendants in cases like this. The first, which is the forcible detainer defendant, is what we call a tenant. That's someone who's been given permission to possess the property. And the second type of case is what we call a forcible entry and detainer. That is a case in which the person who's the defendant was never given permission by anyone to have possession of the property. And I say it that way because forcible entry and detainer is a much higher bar to meet. Now, the procedure in these cases is basically identical except for one difference, which occurs when the citation is served. Uh, the Texas legislature, as part of SB 38, created a special procedure for use in forcible entry detainer cases called summary disposition. What summary disposition is basically a procedure by which the landlord can plead that there are no disputed facts in the case and ask that the case be decided immediately and without trial. The tenant has to receive notice with the citation that the landlord has filed a summary disposition motion. And in order to get to a trial date, they have to, within 4 days of being served, provide the court with a document alleging that there are disputed facts and laying out what those facts are. If you can show that you're not a squatter, that is, that there is reason to believe that you had permission to be there at some point in time, then the landlord cannot prevail in the summary disposition motion. And if they've pled this as a forcible entry and detainer, they may also fail at trial. And so showing as a tenant that you are in fact a tenant and not a squatter could be a difference between having a day in court and not having a day in court. So how do you prove you're a tenant? Just a brief list of things that you can rely on as evidence. A written lease. If you have records of payments made to the landlord, that's significant. Any correspondence with the landlord showing that there's a relationship could be significant. If the landlord's made prior demands for possession or rent, that could potentially suggest that there's landlord-tenant relationship. If they briefly tried to evict you, as a tenant, and now they're trying to suggest that you're a squatter, that can be significant. Also, in certain limited post-foreclosure situations, an ownership document such as a deed could demonstrate that you're what's called a tenant at sufferance and not a squatter. Because the stakes in these motions are so high, our recommendation is you as a tenant should keep evidence of your tenancy, even if you don't think you're at risk of eviction or believe you'll ever be at risk of eviction. So how do you respond to the summary disposition motion? First thing you want to do is contact an attorney. You also want to contact the clerk of court and see if they have any resources or assistance they can provide. They can't provide legal advice, but if the court has sort of a template response, it may be a good idea to take a look at that. I don't know of anything like that yet, but we're still early on in this. You then want to file your written statement as soon as possible, but definitely before the 4 days are over. You want to allege, like I said, any facts that dispute what the plaintiff is alleging. So, for instance, if you're a tenant and the person who's trying to evict you suggests you're a squatter, you want to allege that you have a landlord-tenant relationship or an owner interest, or you may even want to dispute that the plaintiff followed the necessary procedures to get an eviction. You also want to file with it any document supporting the statement. Obviously, file soon, but file even if the response is late. And then always, always, always show up to court on one of these. Important to note, if you respond and the court denies if the court basically grants the motion for summary disposition, that doesn't cut off your right to appeal. So you may still get another bite of the apple there. But it's really, really important that you respond quickly if you get served a summary disposition motion. So we've gone through the notice requirements. We've gone through the citation and possible pre-suit motions. Now we get to the actual trial itself. Justice courts, there are 16 of them in this county. They're in 8 different precincts, 2 to a precinct. We sometimes refer to the justice courts as the Wild West because they're meant to be courts in which any person can go in and represent themselves without the need for an attorney. What that means in practice is that the judges have a lot of discretion how they run their courtrooms, and they can look very different as far as what the trials look like from one JP court to another. There are a couple of precincts in this county in which the actual trials in each precinct look different from one court to the other court. Our recommendation, if you're going to trial, would be to get to court early, but definitely to arrive on time. The reason we recommend going early is because some courts host community groups, which can provide assistance or resources available, which could help in resolving the case or which could result in you getting legal representation in some cases. Some courts also ask that you confer with the other party before going to trial. And so if you show up early, that gives you more time to resolve the issue. When you're checking in, again, this can vary dramatically from court to court. Some courts allow you to check in at the front anytime before trial, and they'll direct you out to the hall, either to deal with the opposing party or to talk to the community groups. Others will require you to remain in the courtroom and will basically call every case to see if the tenant is present. If you have any questions about how that process is going to work, I recommend talking to the clerks before. Once everyone's checked in, the court actually begins. The judge takes the bench. They may give instructions on how the court works prior to calling the cases to trial. In almost all cases, the judges are going to begin by hearing the plaintiff's case first before giving the defendant an opportunity to respond. It's important to allow the plaintiff to basically provide the information to the court, not interrupt or try to dispute things, and to wait your turn, but also to listen. When it's your turn, you have the ability to either provide testimony or provide evidence. You want to be prepared to answer the judge's question, to provide any documents that you might need to prove up your defense. Important to note, we sometimes get questions about what it would take for a court to have a reset. Especially under new rules, the court's very limited in terms of what sorts of resets that they can grant without the permission of both parties. So it's very likely that if you go to trial, the judge isn't going to be able to reset your case absent some form of agreement. At the end of the trial, the judge is going to issue judgment in favor of one party or dismiss the case. In rare instances, there may be a delay, but again, that would require the agreement of the parties. Try to get a copy of the judgment for review and for your files. And during the process, always be respectful to judge, the court staff, and the opposing party. One final note, if you need special accommodations in justice court, either a Zoom hearing or the need for interpreter, our recommendation is call the clerk of court early and ask for assistance. Again, some courts are going to operate differently than other courts. Some courts are going to require that you provide advance notice and show good cause you're asking for the accommodation. Others, as a matter of course, just allow virtual appearances. So I would defer to the clerks on those questions, but just make sure you're asking court staff for help as you need it. As I mentioned, some judges encourage settlements between the parties or provide resources to facilitate settlement. Most judges would rather the parties settle it themselves rather than have to make a decision. And so settlement could be a good off-ramp, potentially. Settlement agreement requires both parties to agree to specific terms. The parties will dictate what those terms are. A lot of courts will have either recommended settlements or they may provide standard forms which state specific things. But keep in mind, a settlement can be whatever the parties want it to be, so long as the parties agree. A good agreement is going to define what the actions are that are going to be taken by both parties. And they'll basically provide information about what happens if the parties default on the terms of the agreement. So a good example of this would be a simple move-out agreement. So the landlord and the tenant decide they don't want to go to court. The tenant says that they'd be willing to move within 10 days. The landlord and tenant can agree that the tenant will return the keys within 10 days. And if the tenant does not, then the landlord can take it to court and get judgment. That's the sort of settlement we're talking about. Another type of that would be sort of payment agreement, whereby the tenant agrees to come current within a particular timeline. And then, that's another way in which a settlement could, come about. Settlement must be in writing and signed by the parties. It should also be filed with the court. An informal and unwritten agreement between the parties is not enforceable. So no handshake deals. You actually have to put it on paper. Settlement agreement obviously involves parties giving up rights, may impose penalties if the party fails to comply with the agreement. So important to note, if you are a tenant and you're looking to settle a case, make sure that you are able to meet the terms of the agreement before signing it. Just an additional note, like I said, many courts provide standard forms. These aren't always appropriate depending on the terms of the agreement. So there's, for instance, one court that has a standard agreement that always requires move out. If the parties are agreeing to a payment plan, it's important that they not use that form, its state which requires the tenant to move out. Or else, if they both sign it, then it will be required both to pay an amount and also to move out. So, if you're given a standard form, feel free to alter it however you need to. Or if they have a standard form, or if the standard form is too cumbersome to modify, I'm not embarrassed to admit, I write a lot of settlements out on legal pads. Just make sure that whatever agreement you're entering into, that the written agreement reflects what the parties actually agree to. So let's say that you are a tenant and you lose a trial in justice court, but you believe that the court got the issue wrong. There is an appeals process. The way this works is that within 5 days of court, the tenant is required to either pay an appeal bond, which is normally set 2 months of rent, which most people can't do, or to file something called a statement of inability to afford court costs. You fill that out, you can pick it up from the clerk, you fill it out, and you return it within 5 days of the judgment. Under new rules, you're also required to file a separate form verifying that you have a good faith belief you have a meritorious defense, and that the appeal is not solely for the purpose of delay. So it used to be that last year, anyone could appeal an eviction judgment for whatever reason. This year, they actually have to have some belief they have a defense. Keep in mind, both the SOA and the verifications are signed under oath. So, don't lie on those forms. The statement of inability to afford court costs can be challenged by either the other party or the judge. If that happens, you want to talk to a lawyer for assistance on how to handle that. But basically, the court sets a hearing, and the tenant would have to basically demonstrate that they couldn't afford to pay the appeal bond. In most cases, that's not a particularly high bar, but those can be contentious hearings. So we recommend speaking to a lawyer if you're facing that. Right now, there is not a mechanism to challenge the verification, the good faith belief you have a meritorious defense. That's not to say that we don't think that there are attorneys who might not try to find a way to challenge that. So just watch that space. Now, 5 days after you file your SOI, you're also required, if you're going to stay on the property during the appeal, to make an initial deposit of 1 month of rent to the court registry in order to avoid a writ of possession. We'll talk about that a little bit on the next slide. Keep in mind, even if the writ of possession is issued, your case will still be transferred to the county court at law. So there are instances in which someone who is moving out has an eviction judgment against them and believes they have defense. They might file the appeal, not pay rent to the court registry, instead move out rather than face the writ of possession. They still have a right to have their case heard in the higher court. Once the case is sent to county court, it's assigned a new court, it's assigned a new cause number. And so you want to check the mail regularly to see if the court has sent any information, because they should provide you at least an initial notice of trial that should provide information on the trial date, the cause number, and provide instructions on how to file exhibits. So payments to the court registry, this is another area that's relatively new. So it used to be last year that the payment requirement only applied to non-payment of rent cases. That is no longer true. Now there's a requirement that every tenant who's appealing their eviction pay rent to the court registry. Now keep in mind, there are two types of payments. The first is the initial deposit that's due 5 days after judgment. And the second are payments that are paid basically as rent comes due. So let's say it's the 17th. You make your payment to the court registry today. You would be required to make another payment of rent at the beginning of March unless the case has already been heard by county court at that time. Now, keep in mind, this is true even if there's no agreement to pay rent. If there's no lease agreement stating how much rent is owed, the judge is required to set rent, determine a fair monthly value for the rent. And if the fair monthly value is less than $250, the tenant's required to pay $250 into the court registry. Should the rent not be paid at any point in time, the landlord is able to get immediate writ of possession either from the justice court or from the county court at law. And they don't need to set a hearing on the default as they used to last year. So be aware, these registry payments are more important than ever. You want to keep up with them. And if you start to fall behind, you need to be prepared to leave quickly because there's no telling when the landlord might ask for the writ of possession. So what do you expect in county court? The main difference between county court and justice court is that procedures are uniform and the courts use a much stricter rules of evidence. What that means is that this is going to look a lot more like what you might normally expect the court to look like. Cases are heard de novo, which means that they are heard basically entirely new. What happened in justice court doesn't matter so much. And that means that landlord also has to prove up their case all over again. Landlord has to prove it up with both testimony and evidence. If they walk in without evidence, that's a big problem for them. Now, keep in mind, you also will want to file any evidence that you have supporting your defense. And if you don't, you could be waiving the right to raise those defenses. There are different rules, I think, throughout the state on when things can be filed. Here in Harris County, the courts require that any exhibits be filed the Wednesday prior to trial. If you can, file it at least 5 days prior to trial. When you're actually going through the process, judges are going to need to enforce the rules, which means that we generally recommend, if you can, to get an attorney for help. If you can't, though, my recommendation would be to watch some of the cases and some of the attorneys to see how they present their case. Important to note, judges, do need to follow the rules. They also try to balance that against the need to allow pro se parties to participate fully. So they're kind of doing a balancing act. Do what you can to follow the rules and present your evidence the way the best way you can. Now, should you be unsuccessful at county court, the court sets an appeal bond. You have 10 days to pay that bond in order to stay the judgment. If you don't, then the writ of possession can be issued. The cost of an appeal bond is usually about 10 months of rent, though. So most people couldn't afford to appeal to the Court of Appeals anyway. Additionally, an appeal to the Court of Appeals would require that there be some procedural error from the court or the judge, and would require that you get a record of the trial transcript. Most people are not going to do that. So, I mean, the better way of thinking about this is that almost all cases, county court is sort of the end of the line for these sorts of cases. Before we move on, let's talk a little bit about what to expect as far as public and subsidized housing in these cases. There are different programs that might have different rules. These rules are going to be spelled on the HAP contract. This is something where you're going to want to talk to an attorney and review the specific rules in your instances, just to make sure that before you raise a defense, the landlord's actually following the rules. Also important to note is that in the case where you're paying rent to the court registry, the court can only require you to pay the amount that you would owe under your HAP contract or under whatever contract you have. If the government pays a share, you're not required to pay that share of rent to the court registry. If for some reason you're in justice court and the court orders that you pay the full amount, there is a process for contesting that. You have to file what's called a rent contest. You file that within 5 days of the judgment. So it's basically the same deadline as the statement of inability to afford court costs would be due. And basically provide evidence to the court that you're on public housing and that the amount that should be paid to the court registry is a lesser amount than they've ordered. The court then sets a hearing date basically to consider the evidence. And again, you'll have an opportunity to present your evidence at that point. If for some reason the court still finds that you're required to pay the full amount, there are some appeal processes there. But at that point, you really need to be talking to an attorney. The new rules do place limitations on your ability to appeal, that sort of controversy to the county court. So, worst case scenario, what happens if you lose at JP court and can't appeal, or you lose at county court and that's the end of the road, or if you fail to pay rent in the court registry and the landlord asks for writ of appeal? Writ of possession. So the writ of possession is a legal term for the document that allows the constable to remove the tenant from the unit. Prevailing plaintiff can request a writ of possession from the court within 5 days of the judgment when rent isn't paid, or basically within the 10 days, after 10 days, after a county court law case. The constable is currently required to serve the writ within 5 days of receiving it, or the landlord can contract with a different law enforcement officer to serve the writ. The writ has to be posted 24 hours to execution. Upon execution, the constable can remove the tenant and their property and change the locks. Writ may not be executed if it's raining. So we sometimes get questions about what a timeline for these cases actually looks like. These are both what we might call as short timelines. The new laws do codify certain requirements about when things need to be heard. So for instance, trial being heard between 10 and 21 days of filing of an eviction. So if you are going through the justice court process, the short timeline is about 21 days. That's about as quick as the landlord would be able to get you out from the service of the notice to vacate to the actual execution of the writ. With an appeal, that timeline extends to about 46 days. Now, again, these assume that everything happened about as quickly as possible. In reality, these timelines are going to be a bit longer. Without an appeal, I would expect it could go a little bit over 30 days. With an appeal, it could be up to 50 days, 60 days. Those are just estimates. But if you're wondering about sort of how quickly would you need to leave if you're facing a situation like this is sort of a good precautionary guide. Now, that sort of ends the eviction part of this. But we do get a lot of questions about what happens if the landlord attempts what we might call self-help remedies. As a general rule, self-help is not allowed. If you're talking about the landlord sort of locking you out of the apartment and refusing to let you back in, that is not allowed under the rules. They cannot exclude you except in cases where there need to be bona fide repairs or there's an emergency. They could exclude you if the property is deemed to be abandoned, removing the contents. There are limited rights to conduct what we call a lockout under TPC 92.0081D1. We'll go a little bit more into depth on that in a few slides. Or they exclude you, obviously, if there's a writ of possession that's being executed. Likewise, they can't shut off your utilities except in cases of repair or in very limited circumstances if it's authorized by the property code. Keep in mind, self-help remedies are not allowed even if you're behind on rent payments. And so if the landlord violates your rights either by locking you out or by shutting off your utilities, you do have the right to file a lawsuit against them, basically either to get the utilities restored or to get back in the unit. If you're talking about a lockout or a wrongful eviction, we call that a writ of reentry. And if you're talking about utility shut off, that's what's called a writ of restoration. You file those lawsuits in the precincts where you live. If you cannot afford to pay the court costs, you can always file using something called a statement of inability to afford court costs. That's the same form you would use to appeal. It's just being used now, basically get fees waived in order to file one of these lawsuits. So briefly, like I said, there are some limited instances in which the landlord could lock out a tenant. The code conceives of these lockouts in instances in which someone is behind on rent and the landlord is trying to get the tenant to talk to them. The lockout needs to be authorized under the lease. The landlord has to give advance notice, and they're required, if they're going to lock you out under that section of the code, to provide you information on how to get a new key to the unit within 2 hours of making a request. Now, you might, that's 2 hours any time of day. If you're out of your house and they perform a lockout and it's 2 in the morning, they have to provide you a number to get a key, within 2 hours, even if it's 4 in the morning. If they don't do that, then they're in violation of the code and they're subject to either writ of reentry or potentially a separate affirmative lawsuit. If you're filing a writ of reentry, either because you've been improperly locked out or because you're engaging in self-help eviction, the way this works is that you file your lawsuit in the justice court, along with your statement of inability to afford court costs if you believe you're entitled to a fee waiver. Once you file this, the court is required to set the case for what's called an ex parte hearing, which basically means that the landlord does not need to be served prior to having the hearing. It is usually best practice to try to inform them of that, but you don't need to go through the formal service process. At the hearing, the judge hears the evidence. They agree you're illegally locked out. They can issue the writ of reentry and give it to a constable, basically with orders to find the landlord or an agent of the landlord to force them to allow you back in the property. In addition to the writ of reentry, you can also file a separate lawsuit to ask for damages. There's also an option to terminate the lease as part of that lawsuit if for some reason you wish to do so. Utilities, the rules about filing a writ of restoration are basically the same. You file it, the court sets it for an ex parte hearing. It's usually best practice to inform the landlord that you're going to have the hearing. The judge agrees you're disconnected. You get your writ of restoration, constable serves it and informs the landlord that the utilities need to be restored. And yeah, damages can also be recovered in those instances. Finally, we get a lot of questions when we talk about move out about what to expect with security deposits. The landlord is allowed to keep and deduct from the security deposit any amounts for damages to the unit or to cover charges or arrears that the tenant's liable for under the lease or breach of the lease. So in most eviction cases for non-payment of rent, the landlord can rightfully withhold the entire deposit to cover any amount that would have been owed on the lease. Assuming that that's not the scenario we're talking about, the landlord has an obligation to refund the security deposit on or before the 30th day after the tenant surrenders the unit. You have to give the landlord a forwarding address to trigger that requirement. The landlord is required to provide an accounting if they're going to retain any part security deposit. They cannot retain any portion to cover normal wear or tear. We usually recommend that before moving out, you schedule a walkthrough to document any damage that may or may not be in the unit. That way, if they come back and attempt to retain amounts that would be improper, you have evidence that you did the walkthrough and that whatever grounds they have for retaining it are baseless. If the landlord does not return the deposit or give you an accounting within those 30 days, there is a process for suing them for those amounts plus damages. And there is a presumption that the deposit was wrongfully withheld if there's not an accounting. This is an area where you should seek legal assistance. These cases do allow for attorney's fees, so there may even be private attorneys who'd be willing to look at a case like this. So one more sort of substantive slide before we get to questions. Some additional tips. Make sure you get ahead of the problem. If you're thinking that there may be a problem, talk to the landlord, see if you can make arrangements before this actually becomes a legal problem. Rental assistance may still be available. It's certainly not like back during the pandemic where there's a lot of it out there, but I know that there are a few courts that still have connections to groups that want to fund tenants. So check local organizations. Make sure you take advantage of community resources offered by the justice courts. If you need legal assistance, there are a number of groups out there doing this work. There's my group, Houston Volunteer Lawyers, sometimes has people who handle evictions. There's a new group, Houston Eviction Advocacy Center, that, like us, work some of the courthouses. Just make sure that you're asking for help from credible groups that have lawyers who are working for them. And then finally, just to reemphasize this, if you're having issues with the condition of the unit, make sure you pay your rent and then contact someone for help in getting the repairs. So that basically covers it for today. Thank you so much for listening. If you want to apply for our services, we have information here. And yeah, I'm ready for questions.
Okay. Thank you very much, Benjamin. I wanted to ask, well, I don't see any questions in the chat, first of all, or online that anybody posted. But I wanted to ask, what do you think is the biggest takeaway or the biggest change in the new state laws that would impact tenants that they need to keep at the forefront?
I'd say the fact that there's now a limited right to cure is one of the things one of the few bright spots for tenants in that law. It is narrow. It only applies in cases where it's non-payment of rent. It's only for basically the first time you're late. But if you're facing, a challenge, knowing that the landlord has provided you that right to cure, can help you sort of plan for the future. If you've been through this process before, the biggest change might be that the notice to vacate, are no longer, defenses. That if you get it, basically the court is going to consider it properly delivered. Um, if you're facing something other than non-payment of rent evictions, the fact that you have to pay rent to the court registry, that's big. And then, and I know I'm just sort of going through the changes as they come, but they're all rather significant. The fact that you can't appeal without believing you have a meritorious defense, that could trip some people up. So, certainly there are a lot of changes. There's a lot still to be litigated. We haven't even talked about CARES Act. That one is pretty big, even though if you ask my professional opinion, I think at the end of the day, those requirements aren't going to withstand legal scrutiny. But you need to be aware that if you're in a CARES Act property, the landlord may still try to give you a 3-day notice and evict you. So,
Okay. I did have a question too. In the beginning, if and correct me if I'm not if I didn't hear you properly, um, that you said the state in some cases the new state laws are based on how the judges interpret them, or that
well,
there could be some change or some differences.
so I mean, the way to think about this is that you have the property code, and the code basically sets out what the law is. And then you have the rules of procedure, which, the Supreme Court promulgated those rules. I still think those are subject to notice and comments, and so those may actually change. But then there's the actual practical side of how are judges going to read this and apply the actual statutes themselves. And, the big one is the CARES Act, because again, I think there's some constitutional questions there. And so some judges are going to basically find that that part of the law violates the supremacy clause, and they may enforce the 30-day notice requirement. Some might not see it that way and say that, no, we're going to follow the Texas property code, in which case, there might be a judgment, even though there was no 30-day notice to vacate. Some may just be waiting to see what the courts of appeals do with these. There may be other areas that have constitutional questions. The point is, we have the black letter law, but a lot of how these cases are going to be decided is going to come down to how judges actually apply that law. And, we've learned that as we practice and as, courts decide these cases. And so the point is that, the code is not going to change, but our advice on how to deal with particular questions, could change depending on what the courts do.
So, so what are we to do as consumers to make sure that judges are not kind of,
Well, I mean,
I don't want to kind of
I
put
just,
the words out there,
I
but
just, I just want to be
how do
clear.
you keep it fair?
Yeah, no, I just want to be clear. There are not judges who are going to look to subvert the law here. It's just this is a process with new laws that, we have these dramatic changes. It takes people a moment to catch up. I mean, what I would say is, seek out legal assistance if you have questions. Keep up with these presentations. Like I said, there may be some procedural changes, when the Supreme Court releases their final rules on eviction proceeding. And then, some of these cases are going to go up before the Court of Appeal. You know, the courts may uphold parts of the law, they may clarify parts of law that are ambiguous, they may find parts of law are unenforceable. So it's a matter of just keeping up with presentations like this and asking for help as you need it. And I should mention, none of that's insidious. This is a practical process that we see every time there's a new law that comes along, is that there's often a question of how are things going to be applied. And we just want people to be aware, we're giving you the most up-to-date information. Things could change. They might not. It's possible that everything I say today, stays the way it is until the legislature convenes next session. But just point is, keep up with it. That's all I mean by that particular slide.
And for those that know some people that may be facing eviction, or if you yourself may be facing eviction possibly, please reach out. I mean, don't people are real prideful when it comes to a lot of things like this. if you need the assistance, then ask for the help. If you don't ask, you then potentially just don't receive it. There may be some resources and things out there that are available to you that you are just not aware of, and could be you know putting yourself in further jeopardy of being unhoused if you don't actually ask the question. Um so yeah, then please reach out. Don't wait until you know uh the day before you're supposed to show up for court before you try to find an attorney, or wait until the fourth day of the notice to vacate before you reach out to try to find some assistance or some other kind of services, or even just asking your landlord, hey, I'm late on my rent. Can I pay you on the 10th or whatever? Make some kind of arrangements if you can, because most landlords, give or take a few here and there, we'll take a late payment, and agree to work out some kind of payment arrangement, but you won't know until you actually ask. And if you guys, or whoever else is listening, if you know of anybody else that's actually providing any kind of resources or assistance or anything related to evictions, please let us know. We send these resources out to people all the time that reach out to us that are looking for some type of assistance or resource that we'd like to make available if we can. So if you guys are aware, then please let me know. Again, this session is being recorded. Any resources that Benjamin has already mentioned will be emailed out to everyone, along with the link of the recording of this session, and the link to the YouTube channel if you want to go watch on YouTube, if you go back to review and to potentially share with somebody else that may be facing eviction, or just want to know what the latest update is on what the law is and how it could potentially impact them. So, but again, there are no other questions in the chat. I don't know if any of the participants that are on the Zoom, if you guys have any questions or comments, please feel free to unmute yourself if you like, and chime in. But Benjamin, thank you very much. Certainly appreciate the participation. Thank you, Ms. Camille. The participation of Lone Star Legal Aid. They've been a partner with the A Month of Service collaboration for years since we started this collaboration. So we definitely thank you guys for taking the time out in each month. And we're actually going to be doing our presentations every other month now, so we're not here every single month. Um, so we do encourage you guys to come back if you want more updates, want to ask a question, or think about something that you want to ask, then definitely let us know.
Yeah.
Um,
Please come back.
please definitely come back. Thank you. Tell a friend, let somebody else know. Hey, we got this kind of a service that's out here, this kind of information that's available to you, and let somebody know. So, with that being said, you all have a wonderful remainder of your afternoon. Let's see, what else do we have that's coming up for this month? Next, tomorrow, for our homeowners, we have maintaining and adding value to your home. Next week, we have our property tax valuations, exemptions, and payment options, because the property tax bills just went out and were due at the end of January. And also HOA foreclosures, and our first time home buyer education class that will be on Saturday, the 28th. So if if any of the renters that are out there that are interested in home ownership and that's your option, then we do have one of the HUD certified classes that are coming up that will allow people the opportunity to apply for any of those various down payment assistance programs that are out there. So we do have that classes coming up on the 28th. If you need more information about it, let me know. I'll send out that calendar. And that's about it. So thank y'all very much. Appreciate you. See y'all next time. Look for our calendar to come out for our other upcoming workshops, and we will see y'all next time. Y'all have a good remainder of your afternoon. Thank you, Benjamin.
Thank you.